Okay, I think let's kick off. Otherwise, if we have questions, we're definitely going to overrun. So I'd hate to take up too much of your time. Welcome to today's talk. My name is Paddy Field. I'm the host for today. I'm a solutions architect for First Distribution based in Cape Town. Today, the talk is about the question, is your data compliant? And we had a previous conversation during the week, and it was clearly evident from that short discussion that there is a lot for us to learn and a lot for us to understand about the particular subject. And in this we're talking mainly about GDPR, and for the South African side of it, the POPI Act. For that, the panelists that have joined us today, Jean-Paul Delport, who is our legal advisor from Epsilon, I think, Jean-Paul, Epsilon? Yeah, I think so.
Yes,
thanks, man. Francois Malan, who is our technical manager for IoT and security. And I think on the security side of it, more on the video surveillance and monitoring, if I'm not mistaken. Francois?
Correct. Yep.
And then from our data center division, we have Marianne Voljoen, who is a pre-sales architect in our data management side of the business. So more in the legacy side of the data center. So guys, welcome. Thanks very much for joining us. I just must get my mouse to go wherever I want it to go. So when we started off with this conversation, it was my opinion that in the workplace that I had seen that very few organizations, I might be wrong, and I hope I am wrong, did not fully understand what the act was to start off with, and what the ramifications of not being compliant to these two acts. And our business is no longer just South African. We're part of an international community, so we do, in many instances, have to take cognizance of foreign acts that would penalize us should we not meet them as well. So I think in that situation, JP is going to take us through both of those, if I'm not mistaken. They're the two main ones. I guess there's an American one as well. I'm not familiar with that one, but this has resulted in the absolute growth in data collection or data mining. Businesses now survive on being able to understand their marketplace better than their competition. And in order to do that, they are capturing every bit of data that is available to them, and then subsequently mining it and using it for business advantage. Therein lies a little bit of a dilemma, because a lot of this information is private and confidential. It could be from a business point of view, it can be private individuals, it could be you and I. We've had cases where breaches have taken place with banking organizations where a serious number of credit card numbers and details have been stolen. So obviously this act is there to try and protect us from that type of exploitation. It's not only the protection of the data, but it also covers what you are allowed to use that data for. And I guess JP will go into it. There is a legal expectation from the industry you're in, be it medical, how long must they keep the records for? And then there's obviously what may they do with that data once they've actually got it, and for how long are they able to use it? So I think without further ado, let's understand what the animal is we have got by the tail. So I'd like to introduce JP Delport, or Jean-Paul Delport, our legal advisor, and hopefully he's going to frighten us with what we have not been doing. Over to you, JP.
Hi there, Paddy. Thank you so much for that wonderful introduction. As Paddy said, today we'll just be discussing GDPR. What is it? How are we supposed to be compliant with it? And then obviously the counterpart to it is the South African one. What does POPI say? And obviously, how do the two coincide? How are they different? And are we obviously supposed to be both GDPR and POPI compliant? So I'm just going to share in with everybody, and then we can commence. All right, so these are just the topics that we're going to be covering today. I know a lot of people retain more information through a picture or through some representation, so I thought I would just do a quick summary or bird overview of what it is. So let's go through the beginning of the commencement and the purpose of the two. So GDPR became effective on the 24th of May. A grace period of 26 months was afforded. And obviously the purpose for it is to protect the personal information of the individuals. For POPI, now POPI, portions of POPI became effective in 2013, but the Act itself, 110% became effective as of last year. Now, a 12-month grace period has been afforded. And obviously, again, too, this is the protection of personal information that is now processed. So on a bird's eye view, by the 1st of July 2021, it will be expected that all companies within South Africa are 100% POPI compliant. And then just to cover the guiding principles of what is shared between them is, as we know, it's for the protection of people's information. So people are expected to hold companies accountable with transparency. What security do we use to protect the information? Data minimization is only to retain information that is absolutely necessary. The purpose limitation is in terms of why are we processing it, or the purpose for why we have it, and obviously each of the rights of each of the individual people involved. Now, on a global comparison scale, let's just go through that. From a territorial scope, what makes GDPR, I like to call it the gold standard across the world, is that every country or every organization across the world who deals with an EU individual has to be GDPR compliant. In terms of the South African version, POPI is only restricted to the process of personal information within the borders of South Africa. Now, the second portion is the mandatory data subject access request. In short, this is the ability of a person whose information you have when they request certain information from you. So any person can request a copy of all the information that you have on that individual. You need to provide it to them. GDPR says you need to provide that information within a month, and POPI says within a reasonable time. Now, GDPR and POPI have made it extremely compulsory that a DPO gets appointed within your organizations. These are the people who would be questioned. These are the people who would be audited from a compliance perspective regarding, is your IT infrastructure set up in such a way that you are both GDPR and POPI compliant. Now, the second and last portion is just the breaching deadlines. So if you do have a breach of your system, for whatever reason it may be, you need to inform each and every individual whose data was affected, or if you can't determine whose data was affected, everybody's information that you have, you need to inform all your customers within 72 hours in terms of GDPR, and if it's POPI, within a reasonable time. Now, GDPR and POPI are not two legislations that should be taken very lightly. I'll show you at the end certain fines that have already been introduced to certain companies across the world. But as you can see here, GDPR, there's no criminal charges that can be sanctioned against companies, but they do look at the global revenue of those companies or 20 million euro fine. In South Africa, you either have a 10 million rand fine, obviously dependent on what the extent of your breach is or your extent of non-compliance, or a 10-year imprisonment, or it can be for both. So there's the biggest difference in POPI, is that it covers both a civil and criminal charges that can be sanctioned. Now, the crux of the matter is, what is personal data or personal information? So as we said for GDPR, it is in relation to a natural EU person, and this excludes your companies. So if you are a person who is onboarding a specific partner, and they are an EU natural person, irrespective of where they are in South Africa. So if they happen to open up a company in South Africa and they are an EU natural person, you would be, as a company, obligated to be GDPR compliant when dealing with the personal information of that specific person. Now, there's a subcategory in GDPR, what you like to call sensitive personal data. And obviously that is more knotted down to the race, the sexuality, people's beliefs, their backgrounds, and their personal physical identifiers. So that is information that has to be added to an additional layer of protection. And you can obviously be subject to higher or greater fines in terms of GDPR should that information have been leaked or breached and you weren't compliant. In terms of the South African version, POPI it is for identifiable living natural persons, including juristic persons. So there's one of the biggest differences between GDPR and POPI. POPI will cover the personal information or the information of both companies and the individuals. Now, the criteria, as we said, for GDPR is an EU person, but in terms of POPI, it is as long as you are processing a person's information within the borders of South Africa, so whether they are a natural person not from the EU, as long as they are within the border of South Africa, you are entitled to be POPI compliant in how you will handle that specific person or juristic company's information. We also have a subcategory of information, which again needs a higher protection or higher sense of security that companies will need to have. And that is things like your religious beliefs, your race, your origin, your trade union membership that you have of your employees, so sexual orientation, and health and sex and life. Now, in the IT world, we are an ever expanding and growing environment, and the industry is just getting bigger and bigger. So data transfer has become one of the most important things that people need to consider. In terms of GDPR, data transfer in terms of GDPR says that you are prohibited to transfer personal information outside of your European economic areas. But there are times when international transfers have to take place. If I can use an example, if you have a system that is built on a cloud platform, that cloud server can be placed anywhere around the world, and that would obviously be an international transfer if it is outside your borders. So in terms of GDPR, it says, yes, that data can be transferred, but they have to be permitted to specific countries. And most importantly, their data protection in that country has to be similar to that of what is under the GDPR requirements. In terms of the South African version, POPI says, obviously, for data transfer, we try and force people to process or data transfer their information only within the borders of South Africa, but we know that is not always the case. And so same with GDPR, if you do a cross-border transfer to any third party for whatever reason, their POPI or their personal information legislation has to be that of a similar nature to what we have. But there is the major exception, or the overarching, I like to call it the escape from doing data transfer, or the compliancy of data transfer. But there are sometimes when you are contractually obligated. If you're dealing with, let's use a vendor, let's say Microsoft as an example, and they've got servers all around the world. For contractual reasons, when you as a customer of Microsoft or your end user, when they accept that end user license agreement and stuff, they are consenting contractually to have that information transferred anywhere around the world in order to fulfill the purpose of what that contract is for. So that is one of the clauses that I like to ensure that we have in our agreements, that partners consent to, because sometimes if you don't have a server within South Africa and that data has to go to another country, as an example, that your partners or your end customers have consented to that information being transferred outside of the borders of South Africa to wherever it needs to go to. Now, as Paddy mentioned earlier, data retention and record keeping. It's a very diverse field. There is not really an overarching legislation, as because there's different legislation that will require for different things. So as an example, as what we have on the left here, you'll see that the Value Added Tax Act states that, that invoices of companies must be kept for 5 years. But the Companies Act says that all records must be kept for a minimum of 7 years. So I always say to people, always take the one that is the most stringent, as that will always ensure that you are probably, or most of the time, likely to be more compliant. If we look at the POPI and GDPR, now data retention, or how we keep people's information, is one, as we said, the purpose of why we are keeping it. So we should never keep people's personal information for a purpose that has expired, or for any reason that is no longer necessary. Now, in terms of GDPR and POPI, there are the exceptions, but specifically in POPI, because I know most of us would have to be compliant with POPI within the next few months, is the retention of the record is kept or authorized by law. So as an example, a customer requests from you to have the information forgotten, or they request to have the information deleted from your system. Now, yes, you have to stop processing that information according to that data subject's right. However, you have a legal obligation, as we stated earlier, to retain that information. So the difference is you are no longer processing that information for a specific purpose. So that specific partner or end customer won't be getting whatever it may be, direct marketing emails, but you are still obligated to retain that person's information for a further 7-year period. Secondly, would be obviously responsible party requires a record for lawful purposes. The retention of records is required by contracts, or the data subject or competent person is a child. So that is usually you have to get the consent of a guardian of that person to remove that person's information. Now, I know in the digital age, marketing has become the massive foreground of how we are, as businesses, are able to transact. So in terms of an email marketing perspective from GDPR, we can only include people's personal information if that person within the organization has consented for such purposes. So that's the most important thing, is that for email marketing, that person must consent to the marketing services from your company. If you are sending marketing emails to a data subject and they haven't consented to it, you would be in breach of GDPR. So, to sort of circumvent that, or in a way to ensure that you are compliant, is one, you have your privacy policies that are updated on your company's website, that you inform people that they need to refer to your privacy policies. And two, on all your emails that you send out to partners, they obviously must have the option to opt out or to unsubscribe from those emailers. And obviously that can be a contesting point that you would have to prove should you be audited by any company or by any partner to see if you are GDPR or POPI compliant. These are just the overarching rights of what citizens have: the right to know, what information you have, how are you using it. The request is to, if they request what information you have on them, you need to provide that to them. GDPR says you need to provide it free of charge, where POPI says you are eligible to charge them a reasonable fee for it, but you need to provide it to them. The right to be forgotten, or the right to have your data destroyed or deleted or corrected. Your portability rights, the right to be informed of a breach. Obviously, the partial to opt out, like we said earlier, is you opt out of marketing campaigns or marketing or specific services, or the right to oppose processing. So if a specific relationship with a partner has ended, they can obviously request that that purpose for which you use the information is no longer necessary. So you should no longer be processing the person's information. And just an overarching of how big the GDPR fines I'm looking at these days is, if you look at Facebook, British Airways, Google, the Marriott Hotel, these are just the fines that have been implemented to date on companies for not being GDPR compliant. So, it's a massive thing. We need to take it very seriously. I would definitely say companies, you've got the next few months to be POPI compliant, 100% compliant. I personally do think that, should an argument be made that you weren't aware of these POPI requirements, or that the 12-month grace period was not enough, the counter argument is certain portions became effective 7 to 9 years ago. So there's no reason why companies shouldn't or could not have started the process year by year as the Act became more and more applicable. And that is just the overarching presentation for GDPR and POPI. Thank you, everybody.
JP, thanks very much for that. There's just a couple of points that I picked up from that. one of them is the fines that are leveled on a company. They're not really based. They're not leveled against the company itself. They leveled against executives of that organization. So it's a personal fine. I guess somewhere along the line the company might pay for it, but it is. And from a POPI point of view, there's a criminal element. There's a criminal record associated with that. So I'm not too sure how that stands. If you're a director of an organization and you have a criminal record, are you still able to maintain? Are you still able to be a director of that organization? I guess that would come into play. So from that point of view, I think it's a very serious part of the equation, and it's not to be taken lightly. And just to add to what you mentioned, I've got some numbers here. I'm just going to read them, otherwise I'll get them wrong. Last year alone, and this is from January 2020 to January 2021, GDPR fines rose by nearly 40%. Just GDPR fines. Penalties under the GDPR totaled $191 million, which is not an insignificant amount of money. Data protection authorities recorded 122,000 data breaches. Now, if you consider that for every data breach, you need to inform everybody that is associated with that data breach, that is a significant amount of work. That is a lot. If we take that 120,000 or 121,000 and times that by 10,000 people in that, you've got 1.2 million people that you need to reach out and tell that they've been breached. And I think the one thing that was a little bit startling for me was that that's a 19% increase over the previous year of breaches, not necessarily the fining, but certainly from the breaches. The other thing that was interesting, and I got this through Google, so trust me, it's true. I hope. Was of these penalties, one of them was directly related to the use of specific personal information. In other words, religion, sex, and race. And that was, I think, if I'm not mistaken, H&M. So, people will audit this type of thing, and if you are in breach, you will be in serious trouble. The other thing that you mentioned there was that we still have to take care of information that's gained through maybe IoT or video surveillance, and that is classified perhaps more on the more sensitive side of the classification, because you are able to collect all sorts of things, including very specific information like race, probably religion in some instances, but also images. You're able to record the personal image of that person. So I think this is a good point where we can bring in our IoT and video surveillance or securities technical manager and ask him, having heard what JP has said, Francois, how do you feel that we are or you guys as an industry, how do you stand up against the GDPR, and are you able to conform to it? And do your systems have specific policies in place that you're able to sanitize the information that you have? I guess obviously in your area, a lot of it could be to do with counterterrorism and things like that. So there might be other factors that are at play. But for instance, if we're talking about marching into Checkers down the road, and all of a sudden Checkers know I'm there, and they send me a message that there's, I can get apples free today or something along that line. Maybe not everybody wants to know that, and maybe not everybody wants to know that they're known to be in Checkers. I mean, they're not pinching anything; they're just buying. So really, Francois, over to you. How do you feel?
Yeah, thanks, Paddy. Sure, it's interesting. I think I'm actually quite nervous for some organizations. I think our government at the moment is probably desperate for new revenue sources. And what I've heard today, it's going to be quite an easy revenue source. So if I was an organization, I would definitely heed some of the things that JP's mentioned today and try and get my house in order before the 1st of July. Because I think there's going to be some big examples that are going to come out, you know, when the government gets in order. But nevertheless, you know, from the surveillance and security field and IoT, we've been aware of GDPR for some time now. A lot of the product we use is European product, and we work with a lot of multinationals. So we've had to be very strict with how we secure data, password management. In actual fact, the way software has been developed has also changed a lot. Encrypting between applications and from endpoint devices through to servers, etc., etc. But a lot of it does come down to security policy, becomes policies and procedures, how you manage your data, but how you manage your passwords, all those processes you put in. And we're definitely seeing an overlap with cybersecurity. I think the biggest thing here is a lot of companies are neglecting cybersecurity and good IT policies. But there's certainly a couple of things that JP have mentioned today, very interesting to me, and just sparked a few things. I don't think a lot of organizations are aware of the devices and products they have in their organization. For instance, we've seen a lot of malware attacks where guys have used, let's say, Chinese Linux boxes to do surveillance, and those of you, a lot of them, we know they've got backdoors. They're easy to get hacked. But I was very interested earlier on in a little discussion we had about cloud and looking at where your data is stored in the cloud, where people have similar policies that fall under GDPR. And I've seen it with a lot of the banks that we work with. They just don't want their data out of our borders. Obviously, data sovereignty is an issue. But we're exploding on IoT with regards to video analytics. And I know, we can see the trend, it's moving to the edge, but there is an interim period now where a lot of analytics is done in the cloud. And I don't think a lot of customers are aware where that analytics is being processed. And I see a lot of video cloud services that have recently started up. And I also don't think a lot of people are aware where that video is being stored. We're seeing a lot in China, a lot in Eastern European places, in some places, even South America. And I'm not convinced a lot of those places are meeting all this GDPR. So I think we've got a very interesting time with regards to what we do in our industry. I think our backends on the top systems, and I think a lot of the top customers are looking at how they secure their data, that they've got the right video, the right network, all that in place. But I think there's a lot of people, and it might be a financial thing, that have maybe taken shortcuts in the last 10 years or last 5 years with regards to what they've put down. And I also think there's definitely a lack of data compliance. I just think you go into places where they're doing license plate recognition and customers want facial to track VIP stuff and get demographic data and link it. And even in shopping malls, these little applications we use on our phones when we go into a big shopping mall, those things track us, or online shopping and stuff. I'm very interested to see what happens in the next 6 months in this country. Can't hear you, Paddy.
Sorry. Okay, my mistake. My bad.
Missed you there.
Yeah. I'm back, unfortunately. Yeah, I think there were a couple of points that you made there, and one of them was the cloud, the effect that cloud has on, it's having on the digital world that we're in today. And I think a lot of businesses' data is being collected and potentially not stored in country. It is, and in many instances, you have no clue where that data is being stored. I mean, I can cite examples of storage arrays that report back for a data collection for an analytic application that resides on the cloud provided by a specific vendor. There is no way that I can identify where that storage is taking place and where the analytics are done. And I guess that would be part of the problem that Tesla had with China. I mean, with the cameras, they were a little bit concerned about the fact that potentially it was spying. But honestly, I mean, I might joke about it, but it is a serious matter, because I think you mentioned that was just the tip of an iceberg, in fact, of that particular scenario, that potentially that brand of camera or that manufacturer had been hacked, and that data collected around the world was cloned, for want of a better word, and used for whatever.
Well, I mean, Paddy, it essentially was poor password management. There was a master password that everyone in the organization had access to. So it was just poor policies and procedures with regards to that. And that got out in the public domain, and 150,000 cameras on the internet people could view. I mean, it's just, that
was astonishing.
Nightmare.
Yeah. I think in JP's presentation, we talked about what you're allowed to do and what you're not allowed to do. And we didn't really cover to any great degree the aspects of protecting the data. And I think that's what you have alluded to, is, while we can be GDPR compliant as to forget me, lose me, whatever it happens to be, don't send me emails, but that data still is residing in a corporate repository. And quite rightly, most of the breaches have been through password breaches. The recent ones in South Africa were clearly administrative password breach. And in some instances, it results in ransomware, but in other instances, it results in data being cloned or copied and removed from the premises. So I think that brings in another aspect of the whole equation, where from a distributor, we probably should be talking to our partners more, is how to protect data. Once we've got it, and yes, we understand what it is, we know where we put it, we're cleansing it, but from a legal point of view, we have to maintain that data for a specific period in time. How are we protecting that data? In other words, is it secure? Is that data secure? And I think this is a good point, a good place to bring in Marianne from our pre-sales, from our data management point of view, because 9 times out of 10, most of the data is going to reside in some corporate SAN of some description, or on a file server. And obviously we have 2 types of data. We have structured data and unstructured data. And I think we've previously discussed it. Structured data is tables, it's columns and rows. It's pretty easy to cleanse. It's pretty easy to block. You can have roles and responsibilities. You can make sure that only certain aspects of that table are visible to whoever it happens to be. But I think from Marianne's point of view, where she is more on the unstructured data side of the business, that can, from a business point of view, that can be very challenging, because you're not only talking about file servers that might actually be in your corporate office, but it could be your OneDrive, it could be Box, it could be Simplicity, it could be, I mean, it's endless. It can be on your laptop. So really, Marianne, the question to you would be, do we at this stage have tools to find this data, to locate it within the organization? Can we then categorize it? In other words, can we say that this is sensitive, this is non-sensitive? And do we have tools that we can then enforce with a policy? So really, over to you.
Thanks, Paddy. Yes, we believe we can assist in 5 areas. The first one is to locate where is personal data stored. Can we search that data? If we know where it's stored, can we search it to find personal information? And can we assist to minimize the data that we are keeping? How to protect the data, and then to basically restart the process by monitoring every aspect of the data that we are protecting. So like you said, the easy data locations is the structured data, the CRM, the ERP systems, HR systems. That is structured data, easy to locate. The problem comes in with the difficult data sources, email. What is being sent via email? Our file service in every organization, there's at least one. SharePoint service, or we all have OneDrive these days. And how do we know what kind of personal data is stored there? So how can we help to identify that in that unstructured data? How can we help there? As far as email is concerned, we have got archiving software that will journal all incoming email. So as all incoming email is journaled, it is then basically put into a structured system where you can enable classification tools to now locate personal data. We've got then alternative software where we can monitor file service, SharePoint, OneDrive. So firstly, we can offer free dark data assessments for data up to 10 terabyte, where we can point out to IT managers what types of data they have on their file service in their SharePoint or on OneDrive. So once they know what types of data they have, they can then build an idea of what types of data there is and where personal data could be stored. And once they have an idea of where personal data could be stored, we can then expand on the software that we have to actually now actually go and scan the physical files to find personal data. And once the personal data has been found, we can put rules into place what to do with that data. Is it just a report that we want to extract and make people aware of what types of personal data they are storing? Rules can be put into place to automatically, based on the classification tags in the software, rules can be put into place to then put expiration dates on the archived data. And then data can then obviously be automatically deleted when the expiration date has arrived. But those are all software that we've got available to our partners and that we can assist with assessments and basically just going with our partners to customers to assist with compliance assessment.
Great, thanks, Marianne. I've just got one question. It is in your area, but it's really aimed at JP. Obviously we've, from a data protection point of view or data management point of view, we've been collecting backups, let's call them backups for want of a better word, for a lengthy period now. Well, most organizations do. In fact, I think there are very few that, having considered the recent attacks of ransomware, have been quite vigilant when it comes to their backup policies and their practices. But if I'm not mistaken, these acts can be retro applied to this data. So that would mean for me that these archives, these deep archives, would have to be scanned and the policy applied to them. Because I think in the GDPR one, I think at H&M, it was retro applied for a couple of years back for something that they did a couple of years back. So I guess there's a significant amount of work to be done on that, because that is a large amount of data that is archived from a legal point of view. I mean, we need to keep it. If you consider it's a hospital or it's medical, it's probably for the life of the patient and maybe a couple of years thereafter, just in case there's a query on why he died in hospital. Hopefully he didn't. But I think that, Marianne, if I'm not mistaken, the products that you look after have the ability to actually rescan previously archived data. Correct?
Yeah, yes, correct. Something that I actually forgot to mention. Yes, obviously, part of this whole cycle of looking after data is to protect the data, and that is where we come in with our backup solutions. and obviously need to be able that our backup solutions are also protected against ransomware, and that the drives where our backups are stored are not infected by ransomware, because that is normally your first protection against ransomware. You've got good backups, but if your backup software is encrypted, then you can't get, or your backup storage is encrypted, you can't get to your backups. Okay, but now we've got the data that is backed up. We see that a whole lot of companies are just lazy. Instead of just putting in proper backup retentions, they say storage is cheap, and we are just going to put infinity retention on all our backups. Yes, so, and then obviously you need to be able to search your backups to be able to find personal data. The problem is you are not going to be able to find a record of a person when you just search a backup, because all that we store initially, what we search for when we search backups is metadata. We need to know on file server XYZ, we had a spreadsheet called company XYZ, where we know we had personal data. So we need to be able to know what we have backed up, and then be able to retrieve the backups. So to search for personal data inside backed up data is not easy, but we need to be able to then at least protect data against being restored. So we've got in our one of our products, we've actually got protection where it's called a GDPR Guard, where it says a specific data cannot be restored, because it is not possible to delete specific data out of a backed up file, but we can protect certain data from being restored. So we can then import import CSV files with specific criteria where we can prevent data from being restored from the backups, because like I said, it is not that easy to extract data, specific data, and delete data out of a backed up file.
I just want to jump in there, Patty. Sorry, Marianne. I found what you do is quite fascinating, because we had a massive incident with a very large corporate, and I don't know if people understand how much sensitive information is in an access control system. It's ID numbers, it's emails, it's pictures of people, it's everything. And these guys were doing a database backup and took a CSV extract and left it on a desktop somewhere, and it went through, and a couple of years, not a year, let's say a couple of months later, someone picked that up, exported it, they had the whole organizational database. And what you're saying about scanning and picking up these dead databases on systems, it's actually critical, because you don't actually realize how many times there's a dead database lying somewhere that anyone could have access to it.
Yeah, I would back that up. Yeah, I'm sorry, man. I can concur with that, because if I'm not mistaken, recently there was a breach where a significant amount of personal information, and I think it was credit card details and things, was pinched from a briefcase. It wasn't a piece of paper in the briefcase. It was a hard drive in the briefcase. So, I mean, obviously somebody had done a backup and had decided to take it home as the air gap. You know, that's all legitimate. But it was just a plain straight hard drive, and you could plug it into any local home PC, and you could glean all that information. So, yeah, you know, we have to be a lot more careful with what we do with the information. I think there's a lot more interest in self-encrypting drives from an array point of view, because if you have a drive failure, it is possible to unlock that drive and read the data that's on there. Okay, so now a lot of organizations, to prevent that, are either leaving the drive with you. In other words, it's your data, your drive. You destroy it with the compliance in mind, or you use self-encrypting drives, once it's out of the machine, it's actually gone. It's not there. And again, I think most products that we support nowadays, if we're transferring data across the WAN, which is really a very easy place to intercept data, it is in an encrypted form. Very few times do we send out or do the products that we have in our portfolio send out data in a raw format across the WAN. So again, then the breach would have to come from internal, and there we get back to very poor administrative security type posture within an organization where the administrative password is password. I mean, okay, that's probably my most popular one, but you know, I don't have any private information on those systems. But it's not unusual. I mean, I was contacted by a large MSP the other day, and they were asking me how to do restores, and I asked them why, and they declined to tell me, but it's evidence they were locking files. So it was ransomware, and we had to jump through a few machines for me to see what the problem was. And every single machine in that organization had a new password, and they were not alike. So they had taken such a shock that they had gone to the extreme side of it, where if you had a password, you could infiltrate one machine. So, you know, again, it goes hand in hand. Security, protection of information, they should be seen as the same thing. Sorry, Marianne, you were going to say.
Sorry, I've muted myself.
No.
Yes, obviously you need to make sure that you've got enterprise, not just enterprise backup software, also enterprise system where you back up to, and that all the security measures are in place. I was telling Patty the other day that I was once at a company where they were still using backup tape, and everybody is trying to move away from backup tape, and we still feel backup is secure. It cannot be encrypted. You cannot put ransomware on tape. But the Metrofile guy who came to collect the backup tape for the day was going to the bathroom, and then he left it in the bathroom and walked off without it. So somebody came in and said, does somebody know who this belongs to? So there's the company's backup tape. So the idea is to move away from anything where data can be tampered with. So enterprise backup systems that can that has either got a copy on the cloud where data is encrypted in transit. We've got our backup appliances where data is securely stored, that is so locked down that it's got intrusion prevention software. So it is absolutely imperative to look at the backup systems that you've got in place, and not just think that because I've got a copy on a hard drive and I'm taking it home every day, my data is safe and I've got a copy of my data.
Okay, guys, we've got a question here from the audience. I'll read it. As a company in SA, where should we be worried about? GDPR or WinPoppy? So I guess, JP, you answered that. But would you like to go over it again?
Yeah, no, I'm happy to cover it again. So the question's from Nazir. So Nazir, the biggest qualification is because we are a company based in South Africa, immediately you should be saying, okay, how am I POPI compliant? You are processing that information within South Africa. You are a company based in South Africa, so POPI automatically becomes applicable. For GDPR, it is more specifically towards a natural person if they're a person or a citizen from the EU. So wherever from the EU area or within the European Economic Area, anywhere from one of those countries, whether they're based in the EU or in South Africa, GDPR would then become applicable. So if you have an EU citizen who has set up shop in South Africa, then you have to be both GDPR and POPI compliant.
Well, thanks, JP. I think there was one other question that came. Sorry, Francois,
Yeah,
go.
sorry, and JP, I mean, in most organizations we work with, they prefer to be GDPR compliant. You know, the feeling is that sort of tops Poppy most of the time.
Yeah, so I like to say GDPR is sort of the golden standard across the world. Only reason why I would say that is because it protects natural EU persons irrespective of where they are around the world. And that's the reach that Poppy doesn't have, you know, and it was very fortunate for GDPR to have come out post our legislation being Poppy. So Poppy will definitely have to be amended by the relevant authorities to be to the standard of what GDPR currently is.
Well, JP, that brings in another question. Who can audit you? Who has the right to request an audit of your compliancy versus on GDPR? I guess from a GDPR position, it must be somebody associated with the EU. But with a Poppy in South Africa, who can request that?
So in terms of within the borders of South Africa, it can be any government authority who you are submitting information to. So it could be SARS, it could be the financial authorities within South Africa if they want to do an audit on your books of the company. But it can also be a partner of the company. So a lot of your contracts, you will see in contracts, is the right to audit. And that gives companies or your partners the opportunity to say, upon reasonable notice to you, we would like to come in to audit your systems to see if you are compliant. So it can be anybody, basically, from public individuals to private.
But if that's the case, then the request from, say, from a private individual can really only be against his record, not other people's records. In other words, are you Poppy compliant based on his personal information, not on Joe Blogg's, I guess?
That's correct. That's correct. It would only be limited to that data subject or that person's information, because they would want to be testing how are you processing their information. It's not about how you are processing everybody else's information.
However, I think if it was a situation that's in a government entity, then I guess their reach would be further than a personal, an individual. They would like to see how you're doing it as as compliance against the Act in total,
Most definitely.
not just for a specific person. Great. So, are there any other questions? Has anybody else got anything that they would like to add to the conversation? I think from here, I hope that it has generated some thought in amongst our salespeople and our partners, that we don't really have a lot of time left, 2 months pretty much, eh? And while it sounds like it's quite a task, there are business opportunities to be had. In every cloud, there's a silver lining, and I guess this is one of them. So, you know, there's the opportunity to provide assistance. There's the opportunity to provide professional services. There's the opportunity to provide physical devices that can assist with this activity. So I hope, just to close it out today, thanks very much for the panelists who joined us. I hope everybody else found it of interest, and please feel free to contact us should you have any further questions, and we look forward to hosting you again. Thanks very much, guys.
Thanks, Paddy.
Thanks, everybody.
Thanks.